A question I'm often asked is, when I meet with the client about an automobile accident case, is my case really going to go to trial? I don't really want to go to trial. And the answer is, approximately 75% of the cases that we're involved with settle without even filing a lawsuit. And the reason for that is, if you can get a settlement value that is relatively fair, you're better off settling the case just because you get the money faster and you avoid all the extra cost. But in about 25% of the cases, we have to file a lawsuit. And the reason we file a lawsuit is either one, the insurance company is being extremely unreasonable, or two, the client is still treating and the 2-year time period to pursue a personal injury case is almost up, and we have to file the lawsuit in order to protect the statute of limitations. Of the 25% of the cases that we file, probably only 10% of those cases go to trial. And the reason for that is, in this day and age, there's a concept called mediation. So if you file a lawsuit, you take depositions, which are statements under oath of the plaintiff, the defendant, and the various witnesses. You do paper discovery, which are answering questions under oath on paper and getting all the relevant documents. Typically then you would go to something called a mediation. A mediation is where there is a court or private mediator, and the mediator's job is to try to settle the case and work with both the plaintiff's attorneys and the defense attorneys and the insurance company. So typically only about 10% of that 25% goes to trial. In order to decide if a case goes to trial, you have to look at what the best offer is from the insurance company, what the cost would be to go to trial, and then the attorney, based on their experience, in conjunction with talking to the attorney, decide to make the business decision whether or not it makes economic sense to try the case or to settle the case.